Hi, this is Greg Gimeno with Chesapeake Wills and Trust. Let's talk about powers of attorney. So, what is a power of attorney and why do you need one? We talk about estate planning as a two-act play. Act number one is what happens if you're alive and disabled. And act number two is what happens to your stuff after your death. So often when clients come in to see us, they are mainly concerned about act number two, which is, where does my stuff go? Who gets it? When a client sits across from the table from us, the first thing out of their mouth is, I want my stuff to go to my kids, or I want to make sure stuff doesn't go to certain kids. But that's where the primary focus is. What's often overlooked is what happens to you and your stuff upon your disability. So, if you are alive and well, you're in control of your stuff. You get to decide what you spend your money on. You get to decide when to pay the mortgage payment, when to pay the electric bill, when to pay the water bill. You make those decisions for yourself. If you're alive and well, you get to make the decisions on your medical care. Do you get surgery? Do you not get surgery? Do you get medication? What kind of medication are you going to take? Those are the decisions that you have to make for yourself while you're alive and competent. Now, if you become disabled, you've had a stroke, you're in the nursing home, you can no longer make your own decisions. Now, who's going to make your financial decisions for you? It's not an easy question, is it? For so many people, when we ask that question, who's going to handle your stuff upon your disability? Who's going to handle your financial affairs? People rarely have an answer. The most common answers we get is, well, I have beneficiary designations on my stuff. That'll be just fine. They'll be able to take care of my stuff. Or my spouse is on my account, so if something happens to me, my spouse will be able to continue writing checks and making those payments. What if you become a widow or a widower? What if your spouse predeceases you and you're the sole person on that account? Now, who gets to manage that account? Now, just having a beneficiary designation on an account doesn't allow that person any access to that account during your lifetime. So we encourage people to make sure all your beneficiary designations are up to date. It's wise because that is how things will pass after your death. Act two of the play. But who's going to be able to have access to that account during your lifetime upon your disability? Same thing with your medical care. Who's going to be able to make your medical decisions for you if you can't? Now, unless you've designated someone, the law books have listed who gets to make decisions for you. And there's a list of priorities. It goes to spouse, if not to a spouse, and to the kids. But again, what if you have no spouse? Then the decision can go to your kids. Notice I said plural kids. I know for anybody watching this video, your kids would never fight when it comes to life or death decisions, or when potentially money's on the line, no one's going to argue in the hospital. But just play along with me. It says all of your kids. It doesn't say the one kid who lives closest to you gets to make the decision. It doesn't say the kid who calls you every Sunday morning gets to make the decision. All of your kids are on equal footing. What happens if you have 3 kids and they all disagree on the care you want? One thinks they know what you wanted, the other one thinks they know what you wanted. Now the doctors don't have any direction. The hospital has to get involved to help direct your care. You could have avoided that by selecting someone to make that decision for you with a healthcare power of attorney form. Healthcare power of attorney says this is the person that gets to make my medical decisions for me if I can't. And you can make sure that the person who's making the healthcare decisions for you has access to your medical records. The healthcare powers of attorneys that we draft all contain what we call a waiver of your HIPAA rights, waiver of your federally mandated rights to privacy for your medical records. Those are great things, the HIPAA rights, but we want to make sure the people who are in charge of your care have access to speak to your doctors and have access to speak to your medical records. So all in the law books, they have a list of priority of who gets to make decisions for you, and whether it's the person or the people you want to make the decision for you or not. They do have a list of priority. What the law books don't say is if mom is in the nursing home and death is imminent, does she want to be kept alive with artificial means? Does she want a feeding tube? Unless you make those selections for yourself during the course of your lifetime, you are pawning that decision off on your family at a time where emotions are high, people may not be thinking correctly, and you're leaving them to guess. So you have an opportunity now to sign not just a medical power of attorney form, but also a living will document. And the living will says if you are diagnosed in one of three conditions: a terminal condition, a persistent vegetative state, or an end-stage condition, and by definition, all three of those conditions, your death has to be imminent. Do you want to be kept alive with artificial means? And do you want a feeding tube? So now let's switch our focus for a second to not medical care, but now your financial affairs. If you've had a stroke, you're in the nursing home, you're otherwise incapacitated, who can access your checkbook? Who can write checks out of your account? Who could sell your house if you need to pay for long-term care and you can't execute the documents? So unlike in the medical conditions where the law books list an order of priority for people who can make those decisions for you, there is no order of priority of people who can make financial decisions for you. So if you don't choose for yourself, don't worry, the government has a plan for you. And don't we all like it when the government has a plan for us, especially when it comes to our finances and telling us when and how we can spend our money. So the plan that the government has for you is something called a guardianship proceeding. So let's say mom is in the nursing home. She's incapacitated. She's in the hospital. She's had a stroke. She can't manage her affairs. And mom is the only one on the checkbook. How do we get access to that? Well, let's assume also mom hasn't done any estate planning. She hasn't planned for Act 1 of the play. She signed no power of attorney. She has no living trust with a trustee to make those decisions for her. So now the kids have to go and apply for a guardianship proceeding in the circuit court where the mom resides. Mom now becomes known as what's called an alleged disabled person. So the kids have to go and get certificates from 2 doctors to prove that mom is incapacitated. Then they have to fill out a petition for guardianship and take that to the courthouse. Now, just filing the petition for guardianship and giving the filing fee and handing over the 2 doctors' certificates doesn't automatically mean that the kids get access to the bank account. In the state of Maryland, a guardianship is what we call an adversarial proceeding. The alleged disabled person has the right to challenge and to contest the imposition of the guardianship. So mom now gets a lawyer appointed for her. That's right, mom's never met this lawyer, knows nothing about this lawyer, doesn't know the lawyer's credibility, whether mom would even get along with the lawyer, but that lawyer has now been appointed by the court to represent mom in the guardianship proceeding. And guess who pays for that lawyer? Mom. So out of mom's assets, she has to pay for a lawyer for a guardianship proceeding that she didn't want, but that she now needs because she didn't plan. So how do we prevent the guardianship process? By having an estate plan in place, by signing a power of attorney, giving people the power to manage her affairs, both from a financial affairs and medical. Every client who comes into our office who does an estate plan, we draft carefully drafted powers of attorney to try to prevent the guardianship, but more importantly, to try to protect your assets, to try to allow the person who's doing the estate plan with us to pick who they want to manage their assets, who the backup to that person would be. Oftentimes that prevents family fighting, family disputes, when we have a person in charge who's able to make those decisions. You have an opportunity now to not take the government's plan that's there for you, but to develop your own plan, to put your own people in charge and in place at a time when you want them to be there. So to find out more information please visit our website, www.chesapeakewillsandtrust.com. From there, you can download a free copy of my book, How to Protect Your Home and Life Savings in Maryland, where we discuss a whole array of estate planning topics, including powers of attorney and the types of powers of attorney that you'd want. Or call our office at 410-590-1900.